So how strong is the Manhattan DA's case against Donald Trump? Let's talk about it in today's video. Hi, I'm Mike Greiner. I'm a lifelong Democratic activist who's concerned about the direction our country is taking. I'm also a lawyer and an academic, and I'm here to help you stand up to the BS of the MAGA crowd. So the MAGA Republicans are going crazy, claiming that the Manhattan DA's potential prosecution of Donald Trump is nothing more than a political hit job, and that there's no basis in the law for this prosecution. In fact, if you watch Fox News, as is my unfortunate plight, you'll see video after video talking about how weak a case the Manhattan DA has against Donald Trump. So how strong a case do they really have? Well, let's check it out as I react to this video interview of a former Manhattan DA prosecutor.
The next guest worked in the Manhattan DA's office and has major doubts about the viability of the case. Former prosecutor Elliot Feelig is here to explain. Elliot,
good morning.
All right, you got three problems with this.
Three questions that have not been satisfactorily answered that make me really doubt the viability of this case and make me question the motivation behind this prosecution. First and foremost, the timing. The underlying acts occurred 7 years ago. They've been known publicly for 5 years. President Trump, Donald Trump, has been out of office for 2 years, so any presumable shield against prosecution is long gone. So why is this case being brought now? Is it just a politically motivated response to the criticism Alvin Bragg received from his former deputy for not pursuing Trump for financial improprieties? That's what it looks like.
Okay, first of all, that's not a legal defense. Clearly, this former prosecutor here is trying to cast shade upon the Manhattan DA's office. But in no court would he be able to claim that, oh, it took them a long time to prosecute me, and that's why I should be found not guilty. The only issue would be if there was a statute of limitations that stopped the prosecution from going forward. But this prosecutor doesn't even raise that, because that's not going to be an issue in this case. Well, let's keep watching. What's his second problem?
You also say that apparently somebody wrote a book about the situation and literally attacked Mr. Bragg, and now this is payback.
Well, that's what it looks like. Why else would you wait 2 years that he's been out of office to bring this case, unless it's in the immediate aftermath of the criticism from that book? I'm also curious, though, why are we even in state court? These are federal election laws, presumably. Right. They're typically and almost exclusively prosecuted by either the FEC or the Department of Justice. I'm not aware of any legal theory whereby these acts would constitute a violation of state law, but not also federal law. The only inference here is that the FEC and the Department of Justice, the Biden Department of Justice, looked at these facts and said there is no viable case here. I don't know anyone who would argue with a straight face that Alvin Bragg is somehow a more competent or respected prosecutor than Merrick Garland.
Okay, let's stop that right there. Number one, I would argue that Alvin Bragg is probably a more aggressive prosecutor than Merrick Garland. Merrick Garland, if anything, is incredibly cautious. That's why it's all the more remarkable that he actually signed off on the search of Mar-a-Lago looking for those documents. From the day I heard that Merrick Garland was going to be appointed, I expressed concerns over the fact that I thought he was too cautious given the environment we're in. That being said, the Department of Justice has not said that they are not prosecuting this case. In fact, as we may recall, there's actually a special counsel investigating Donald Trump. Special counsel investigations are secret, so we don't know all of the different possible charges that are being looked at. There certainly could be a violations of federal campaign finance law. But what's more is state courts are perfectly able to enforce federal law. State courts are called courts of general jurisdiction. They're not limited in what they can decide the way federal courts are. Federal courts can only decide issues that are authorized by federal law. State courts have no such restriction. They can enforce any law. So even if this were just a violation of federal law, a prosecution could be brought for violating it by state authorities. Finally, there is actually a state charge that's being levied against Donald Trump. You see, the way this worked is that Donald Trump's former lawyer cum fixer, Michael Cohen, was in touch with the representative for Stormy Daniels. Cohen negotiated a deal through which Daniels would be paid in exchange for keeping quiet about the affair she had with Donald Trump. The first payoff to a former affair of Donald Trump, at least the one that we know of, was to Karen McDougal, but that was done by the National Enquirer, who took an approach of catch and kill these stories, that they want to pay for the story and then not run it. Well, by the time Stormy Daniels came along, the National Enquirer said, we've paid our price, we don't want to pay for this one as well. That left Cohen with the question of how to pay for it. Well, in October, shortly before the election, and after the pussy-grabbing video came out, Stormy Daniels got tired of waiting for her money and said she was going to go public with her story. In a desperate effort to stop that from happening, and after some phone calls between Donald Trump and Michael Cohen, Cohen actually took out a $131,000 home equity loan on his house and paid her off. Then he turned around and billed Donald Trump for legal fees, which included the payoff, and wherein Donald Trump signed the checks himself. Now, New York law makes it illegal to commit a fraud by lying on business documents. That's the problem they've got. Not only did they not report this as an illegal campaign contribution, that's the violation of federal law, but they also falsified their business records, thus violating state law. What's more is that state law is only a misdemeanor unless the fraud was committed to cover up another crime, which, as it turns out, is the federal campaign law violation. So there is certainly a state law violation, and even if there weren't, state courts are certainly capable of enforcing federal law. Let's keep watching.
Merrick Garland passed.
Right. The feds passed. The DOJ passed. The Federal Election Commission passed. And now the...
Again, they haven't passed. There's an ongoing special counsel investigation. Let's keep watching.
Local guy who we've talked about with the crime situation here, he's going after him. You also suggest the John Edwards defense may come into play.
Absolutely. John Edwards was charged in 2011 under very similar circumstances in federal court where it belonged, with violating campaign finance laws for having hush money sent to a former extramarital lover. His lawyers...
Okay, let's just be clear. At least they're admitting here that there was a hush money payment made to a former extramarital lover. In this case, of course, we're talking about the porn star Stormy Daniels. Let's keep watching.
Successfully defended the charge by saying, look, anyone would pay hush money, candidate or not a candidate, to spare themselves, their spouse, their family from embarrassment. That was a successful defense. It's a defense that's fully available here.
Right.
Okay, let's be clear about something. There are certainly parallels between John Edwards' case and Donald Trump's case. But there are a couple points worth noting. First, John Edwards was not acquitted. He was charged of 6 crimes. He was only acquitted on 1 of them. On 5 crimes, the jury deadlocked, meaning that they couldn't agree on a verdict, meaning that at least a certain portion of them believed that he could have been found guilty. The Department of Justice subsequently didn't go forward with retrying him. So to say that John Edwards was exonerated is taking things a little too far. What's more is that John Edwards was tried, which means there was a question of fact. This was not a slam dunk legal theory wherein the prosecutors did not have a basis to bring these charges. Instead, the jury had to consider the facts to see if the state had proved its case beyond a reasonable doubt. Well, in this case, the evidence is much stronger than in the Edwards case. Why? Because they have the testimony of Michael Cohen, the person who actually arranged the payment and who was in communication with Donald Trump. He can testify to exactly what happened. And of course, the Fox News host will say, well, Michael Cohen is not credible. And they could be right. Personally, I found him quite credible when I've seen him interviewed on TV, but let's set that aside. What makes Michael Cohen particularly credible is that we actually have a tape of him talking with Donald Trump discussing the payoff to Karen McDougal. That would be something that's totally admissible in a state court trial, because as evidence, it goes to pattern. It shows that this is not some exceptional thing here, Donald Trump trying to pay off his former lovers to keep them quiet. That in fact, he directly conversed with Michael Cohen about doing it with Karen McDougal. That's pretty strong evidence, if you ask me. The kind of evidence I would have loved to have in trials that I went through. Well, let's keep watching.
So today, the grand jury may hear from Robert Costello, who was an advisor to Michael Cohen.
Right.
And apparently, Mr. Costello previously told the Wall Street Journal that Cohen told him he paid off Stormy Daniels to protect Melania, who had just had a baby, which was barren.
Right. Extremely unusual for grand jurors to hear from a defense witness. It's extremely unusual to even hear from a defendant himself or herself. That happened maybe in 2 or 3% of the cases I handle.
Okay, let's just take a moment here. Are they presenting this to the grand jury? Yes, they are, which probably is an indication, by the way, that they're getting ready to indict Donald Trump. As I'm recording this video, that still hasn't happened. But that being said, this conversation that they're talking about at the actual trial would be inadmissible. It's hearsay. That's exactly the type of thing that would not be allowed as evidence in a trial. Let's keep watching.
But to hear from an actual defense witness, very, very rare. It's an uphill climb, though.
So ultimately, I read that the jury themselves will vote on whether or not to hear him. So
right.
We might not hear. Well, they might not hear.
That's possible. So first, the grand jurors have to vote if they want to hear from this witness. But remember, grand jury, very low bar. It's not like a trial. Trial, you need unanimous. You need beyond a reasonable doubt. Grand jury, you just need a majority of the grand jurors to say there's probable cause. So unless this defense witness blows everyone out of the water, unlikely to prevent an indictment.
Never boring. All right, Elliot, thank you very much for joining us.
My pleasure. Thank you.
Well, that he's certainly right about. The standard for a grand jury is very low, as opposed to an actual jury at trial. But that being said, just based on what we know, it sounds like the Manhattan DA has a pretty strong case against Donald Trump, despite what Fox News is saying. Well, one prosecution that is still pending that could still be brought against Donald Trump is in Georgia for his efforts to overturn the election. If you want to find out more about that, check out this video over here. I'll see you then. In the meantime, let's hope for continued progress. Thank you.